Okay, we can go ahead and get started. Again, good morning. My name is Janardi Jean Charles, and I would like to welcome you to our first session in this Unemployment in the Time of COVID-19 series, sponsored jointly by the Job Connected by MIT and the City of Cambridge. I'll talk a little bit more about what to expect from this series, but first let's start with some minor housekeeping. Our event is being held through Zoom webinar today, and just in case you're not familiar with the features, I will walk you through it. Unlike a standard Zoom video conference, attendants will not be able to see their video or be able to use their audio to speak. However, we do want to hear your thoughts, concerns, and questions, which you can get to us by using the Q&A button at the bottom of your screen. If you are using a handheld device, this may look differently, and so you just want to take a moment to familiarize yourself with the layout. Additionally, you'll notice a raise hand button at the bottom of the screen. If you raise your hand, one of our moderators will message you directly. This presentation will be hosted on YouTube and Facebook, and questions will be anonymous to the entire group, but the moderators. We're happy to follow up with all unanswered questions after the presentation as well. Feel free to begin using the Q&A tool if you have any basic questions about the Zoom webinar features. Now that we've gone through some housekeeping, I would like to introduce my team from the Job Connector by MIT. You guys can wave. I'm accompanied here by my two colleagues, Hector Acevedo and Ted Downing. Additionally, we have members of our team from MIT's Office of Government and Community Relations supporting us today. If you are not familiar with the Job Connector by MIT, please visit our website at jobconnector.mit.edu. The Job Connector is a workforce development hub that was created to service the Cambridge community. We offer employment services to the local Cambridge residents related to job opportunities, resume building, interviewing skills, training opportunities, and more. Additionally, we partner with local employers and organizations in order to assist in their recruitment efforts, provide space for programming, host job fairs, and much more. Speaking of partnerships, we want to give a huge shout out to the City of Cambridge's Department of Human Service Programs for partnering with us to bring this series to you. The unemployment series will be a three-part program, starting with today's session, which will focus on employees' rights and unemployment benefits. Our next session will be next Thursday on the 21st, in which the city's Community Learning Center and Office of Workforce Development will lead us in a walkthrough while addressing questions and concerns about the unemployment application. Very helpful. And finally, our third session will be presented by the Job Connector team and will focus on remaining job ready during COVID-19. Without further ado, I would like to introduce Beth Myers. Beth is our speaker today and subject matter expert. Beth is an employment lawyer who focuses primarily on individuals and will guide us through employee rights. Beth, thank you for being here. I'll let you talk about your background and you can jump right into your presentation.
Hi there, thank you, Janardi, and thank you for having me. I am excited to be able to reach such a large group of people, especially given what's going on in the world and from my own home. So like Janardi said, I practice at a firm downtown called Powers, Jodo, Margolis, and Mentel, and we represent individuals in employment matters. I concentrate on litigation for the most part that involves discrimination, sexual harassment, retaliation, some failure to pay wages and overtime issues, as well as breach of employment-related contracts. In my practice, I also help my clients obtain unemployment benefits and review and negotiate separation severance agreements. I also do some appellate work on employment-related issues. So I've gone through the material. There's been a lot of change lately in the last few weeks. The federal government has issued new legislation, new guidance. The states have taken it on an individual level, state by state, in order to enact some of that new legislation. And it is overwhelming and confusing. And my goal today is to try and put it together in a form that is more accessible to you. I believe that there will be either my slides or some additional written material available following this webinar. So don't feel like you have to furiously take notes. I'm gonna walk you through what I hope to cover this morning. The first part will be more general workers' rights in the time of COVID-19. This relates to your right to payment, your right to recoup your accrued vacation pay, what kind of rights you have around paid sick time and protected leave, and in particular, how the new Families First Coronavirus Response Act may provide additional benefits and protections to you. I'll also talk about what to do and what your rights may be if you or a family member have become sick with the coronavirus. After I finish that section, we're going to open it up to questions. So if you have a question during this time, feel free to enter it in the Q&A box, and hopefully we'll get a chance to address it. I'm going to launch into unemployment after that, and after the unemployment section, there'll be another question opportunity. So in the unemployment section of the webinar, I'm going to talk about how the CARES Act, which you may have heard of, the Coronavirus Aid, Relief, and Economic Security Act, has caused the Division of Unemployment, which in Massachusetts is known as the Division of Unemployment Assistance. If you hear me say DIA, DUA, excuse me, that's what I'm referring to. Reference to UI is unemployment insurance benefits. But the system in Massachusetts has been changed dramatically as a result of the CARES Act in response to the COVID-19 epidemic. So I'm going to walk through various circumstances in which you are eligible to receive unemployment benefits and what circumstance might make you ineligible to receive unemployment benefits. In particular, I'll talk about the pandemic unemployment assistance, excuse me, which is expands unemployment benefits to those who are typically ineligible, such as self-employed, independent contractors, and gig workers. And then I'll walk through a bit about the filing process and cover, when you can expect to receive benefits, how much you can expect to receive, and how long. At the end of that, I will share some miscellaneous unemployment information and also point you to some helpful legal resources. So like I said, after this part 2, we're going to open it up to questions. And again, you should enter those questions in the Q&A box. If folks don't have questions, there are some slides I've prepared of frequently asked questions. We may or may not have time to go through these. We may or may not need to, given the questions that you all ask, but they are available. And once this document is published, you'll be able to review those as well. So I'm going to get started, and I'm going to start with the employee rights and employer obligations during the time of COVID-19. Before getting into the substance of this, I think it's helpful if we make sure we're all on the same page about a couple definitions. You may have heard on the news or in your own employment situation reference to a furlough, a layoff, and a reduction in force. These are all related incidents, but they are different in very important ways. So a furlough is when an employee is temporarily or partially laid off from work. People who get furloughed, the intent is that they will return to their job after a period of furlough. Furlough can be total layoff for a period of time. So an employee may be asked not to work for a period of days or a period of weeks, or it may be that their hours are reduced. So they're working fewer hours, perhaps 3 days a week instead of 5 for some period of time. Now, one important element of a furlough is that while you're not paid for the time that you're not working, you are still eligible for your employee benefits. So you would still, if you were getting health insurance through your employer and you were furloughed, you'd still be receiving health insurance, even if you weren't receiving pay. A layoff is a tricky word because it has a historical definition and a true definition that no one uses it for anymore. So historically, the term layoff meant a temporary dismissal, like a furlough, although it was a complete separation from your employment. So you were not entitled to employment benefits during that layoff. But the intent was that there was a hope and an intention to bring you back on following the layoff. So a true layoff is you're dismissed temporarily and the employer intends to bring you back. However, almost always when I hear people talk about a layoff, they really mean a permanent termination and separation from employment, similar to a reduction in force, which is the third definition here. When an employer eliminates a position or eliminates a number of positions and does not intend to fill those again anytime soon, that is a reduction in force. I would say that today, layoff and reduction in force are interchangeable. Layoff is arguably used incorrectly, but it can be confusing. So the important things to ask in your situation are whether there is an intent and a plan to bring you back to work, and whether you will be paid during this period of time, and whether you will be entitled to continue to receive employee benefits. All right, so if your employer shuts down or starts to operate at a reduced capacity as a result of this epidemic, you still have a right to be paid in full and on time. So an employer cannot tell you that due to economic circumstances, they can only pay you for half of last week, even though you worked the full week, or they can't tell you that they're going to reduce your pay to half your hourly rate and continue to have you working. If they are shut down, they need to pay you for the time that you worked. This is for hourly employees. You aren't entitled to pay for time you didn't work. But if you were working, let's say Monday and Tuesday, and the employer shut down Wednesday, you should be paid for Monday and Tuesday by the next pay period. If you are salaried, it depends on how much of that week you worked. If you worked part of that week, it's likely that you'll be entitled to payment for the full week. And again, payment needs to be made timely. It doesn't need to be made that day of shutdown, but it needs to be made within a week and certainly by the next pay period. Similarly, if you are laid off or your workplace shuts down, you have a right to be paid all of your accrued vacation pay. So if you're terminated, if you're laid off, in addition to any wages that you earned, your employer is obligated to pay you out your accrued vacation pay within the same period of time, within a few days, certainly by that next pay period. If you're in a furlough situation or there's a temporary layoff and your employer has indicated that they're going to bring you back, you and your employer can agree to continue the employment relationship, and your employer can hang on to your vacation time. However, if at some point it becomes clear that the employer is not going to bring you back, at that point, you should be entitled to your accrued vacation pay. So earned sick time. Here in Massachusetts, this is entirely separate from the coronavirus epidemic. Even prior to COVID-19, there's a legislation in Massachusetts that entitles most employees to earn up to 40 hours of protected sick leave. If you've worked for your employer for at least a month and you have worked the appropriate number of hours and do not believe that you have accrued this sick leave, that would be a violation of this law. I've provided information here about getting in touch with the Attorney General's office, filing a complaint online. But if you are laid off or if you are partially unemployed, your employer cannot force you to use this earned sick time for those purposes. Similarly, if you are a Massachusetts employee, regardless of your immigration status, you are entitled to this earned sick time. Massachusetts earned sick time, like I said, is unrelated and separate from the COVID epidemic, but it can be used for leave necessary that is caused by the COVID epidemic. I'm going to get into the federal sick leave legislation that's passed recently and talk a bit about how the two work together. But if you have become sick yourself, if a public health official or a healthcare provider is requiring you or a family member to quarantine, you are entitled to use your earned sick time. An employer cannot prevent you from using that time. Similarly, if a public health official or your doctor has recommended that you quarantine and you're following that recommendation, you are entitled to use that earned sick time. Now, the gray area is where the Attorney General's office is encouraging but not mandating employers to allow their employees to use earned sick time. If you're missing work because your child's school is closed as a result of a state or local authority order, you may be able to use earned sick time and should inquire of your employer. But again, right now that's not mandated. Similarly, and this may be more of a gray area, if you refuse to attend or participate in a particular work-related event because it requires participation in a crowded situation or travel, or if you refuse to report to work at all due to concerns around COVID-19, your employer can, but does not have to, allow you to use earned sick time. And we'll get into whether you would be entitled to unemployment in some of those situations a little bit later in the webinar. So if you want to learn more about the Massachusetts sick leave, there's some websites here. And again, we're going to publish the material so that you'll have an opportunity to review it. But in general, it's the Attorney General's office that enforces the Massachusetts Earned Sick Time Law. So if you want to search the AG's office website, they provide frequently asked questions and some additional guidance in the time of COVID-19. So in response to the coronavirus crisis, the federal government passed legislation known as Families First Coronavirus Response Act, or the FFCRA. Now, this statute affects employers of a certain size, employers who have fewer than 500 employees, but more than 50. So necessarily, this legislation does not impact or affect many people who work for smaller employers who employ fewer than 50 people, or for really large employers who employ more than 50. However, if you work for an employer that is within that range, between 50 and 500 employees, this includes all public employers, regardless of size. This statute provides up to 80 hours, or the equivalent of 2 weeks worth of paid sick leave, to employees who may be unable to work because you're subject to quarantine or isolation, or if you're experiencing symptoms of COVID-19, or if you're caring for someone who is sick or who's in quarantine or isolation. Additionally, this law grants 12 weeks of emergency paid family leave to employees who are caring for children whose school are closed. The first 10 days may be unpaid. After that, you can earn 2/3 of your usual pay. And there's a daily limit of $200 per day and $10,000 total. And again, in order to qualify for this, you would have need to been employed for at least 30 days, and the employer needs to be within that 500 to 50 employee range. So these rights are different and new from what existed prior to coronavirus. Prior to the coronavirus, we had the Massachusetts Sick Time Law, and we had, you may have heard of the FMLA, the Family Medical Leave Act. The Family Medical Leave Act provides up to 12 weeks of protected leave for certain situations. If you are ill, if you're caring for someone who's ill, but that's not paid. So if your employer doesn't offer some kind of short-term disability pay, you would be taking unpaid protected leave. The new statute provides for paid leave during this time, which is particularly important. So again, the 80 hours up to 2 weeks of paid sick leave is new, and the 12 weeks of paid family leave, if your children's schools are closed, is also a new benefit under this federal statute. I've provided some additional resources on this legislation, and again, this will be available for you, but the Federal Department of Labor is the agency that enforces this statute, so if you're interested in exploring it more, you can go to dol.gov. Okay, so if you or a family member becomes sick, if you are too sick to work or you pose an exposure risk to your employees, an employer can tell you not to come to work or tell you to leave work. They have that right. And An employer may require you to stay out of work because either you or a member of your family are sick or have been exposed to COVID-19. And that's true even if there isn't some sort of official public health order or you haven't been recommended to quarantine by a health official. Like I said at the beginning, any hours that you actually worked, you have to be paid for. So if you become sick or you disclose to your employer that a family member is sick with COVID and they send you home during the day, you need to be paid for the hours you worked. You need to be paid for the days you worked. But an employer can essentially forbid you from working. Like I said earlier, later in the presentation, we'll talk about whether and in what circumstances you may be entitled to unemployment leave during that period. All right, so that's the general section on employee rights, sick leave, your rights to wages and accrued vacation time. I'm gonna turn it over to the Job Connector folks to moderate any questions that may have come in.
Hi everybody, I'm Ted. So just a quick overview for anybody that came in late. This is being recorded and will be live streamed on Facebook, but will also be posted on our YouTube and our Facebook pages after. So if you see any resources in here that you want to check out after, you can find it there. So we have a couple questions right now. One is going to be answered just a little bit later, just because there's some information going on later that'll be more relevant to the question itself. We do have a question that just came in, actually two questions that just came in. So one is, how does someone apply for / get FFCRA?
So that's a great question. I think probably the first place to start would be contacting your employer. If there's a human resources department within your employer, that's where to start. If there's no resources at your particular place of employment, I would need to look into whether there's a way to facilitate direct contact with the Department of Labor in order to apply for those benefits. And I'm happy to look into that further and perhaps offer some follow-up information after the webinar. But as an initial place to start, the Department of Labor is the agency enforcing that statute. And so that's the first place I would start if your employer is not able to help you facilitate that kind of paid leave.
All right, the next question is, if I'm collecting unemployment, can I spend the summer out of state and still collect?
So that depends. If you are collecting unemployment because you've been furloughed or temporarily laid off, the requirement, rather than that you continue to search for work, which is typically what you have to do to receive unemployment, the requirement is that you stay in contact with your employer and that you remain available. So, you know, it's a case-by-case answer, I would say. If there's if you're completely unemployed and there's no chance that you're going to be brought back to your former employer, then there is a requirement that you search for work and you be able and available for work. If you're able to do that out of state and you would be coming back to accept employment, then I would say yes. But if leaving the state makes you unavailable for employment, I think that might be a problem.
All right, the next question is, what recourse would an employee have if they're being forced to go to work in spite of the COVID-19 pandemic?
So I have to say that, you know, that's a big question. And employment lawyers, you know, throughout the country are waiting to see what kind of situations come out of this epidemic. In general, you'll see this later on in the webinar, if you feel unsafe going into work out of fear related to COVID exposure, you may be entitled to collect unemployment benefits. In certain circumstances, depending on the risk of exposure and whether you have any particular health conditions that make you particularly risky for developing this virus, there may be some additional kind of workplace safety rules that come into play. But in terms of what legal rights do you have to bring claims against your employer, that's a really tricky kind of case-by-case answer. I would say, the first step is to determine whether you are eligible for unemployment during the period of time that you aren't able to go into work. An employer that fires you for refusing to do something that you have a fear around COVID, obviously employers can do what they're going to do. Employment lawyers can't stop them from doing that, but they often do the wrong thing, which is why we have jobs. If an employer fired you because you were unwilling to come into work, I would say file for unemployment and see if the DUA determines that you're eligible. In terms of, do you have a claim that you could pursue against them? You might, but again, I think that's going to be a case-by-case analysis.
All right, so the next question is, can an employer reduce hourly pay?
So in many employers are dealing with, economic uncertainty. And in this particular time, unless you are a contracted employee, most employees are employees at will, and they can be fired for no reason or for any reason at all, so long as it isn't one of a limited number of unlawful reasons. When someone comes to me and says that they have been fired or part of a reduction in force, one thing I'm curious about is whether the employer offered any kind of pay reduction. An employer can't reduce your pay and force you to keep working there, but they can offer you, hey, we can't continue to employ you at your current rate. We think we could continue to employ you, or many of you, for longer if you agreed to a reduction in pay. And you can agree to a reduction in pay. If you don't want to agree to that reduction in pay, then you would be separated from your employer. And my advice would be to collect unemployment.
All right, so we do have a few more questions, but I think now we'll let you get back to the rest of the presentation. And all these questions will be answered at the end when we have a longer Q&A section. So we didn't miss any questions. We will get to them, but now I'll send it back to you, Beth.
Okay. Hopefully some of the questions will be answered during this unemployment section. Okay, so like I said, unemployment benefits in Massachusetts have changed dramatically as a result of the CARES Act. This is legislation that was just signed into law at the end of March, and it took several weeks for Massachusetts to adopt and implement the federal guidance. But as of, I forget now, it was several weeks ago that Massachusetts announced that we had adopted and had begun to implement the guidance, in particular with respect to self-employed. So, as I said, the Division of Unemployment Assistance is the agency in Massachusetts that administers and facilitates unemployment benefits. So when you talk about unemployment office or anything like that, we're talking about the DUA. So some of the changes that have been made as a result of the CARES Act and COVID-19 are, there used to be a week-long waiting period at the beginning of your application process. That has been waived. In addition to the weekly benefits that you will be entitled to as a result of the pay you're receiving through your employer, everyone is entitled to an additional $600 a week in benefits for 13 weeks. And that 13 weeks is added on to the traditional 26 weeks of employment benefits. So during this time, folks are eligible for 39 weeks of benefits, 13 of which you would receive that additional $600. Depending on how things go and what continues to happen with this virus, it's possible that the government will pass additional legislation extending those COVID-related benefits, but as of now, it's limited to that 13 weeks and ends effective July 31st, 2020. Other changes are that if you miss deadlines or your employer misses deadlines as part of the filing process, they may be excused for good cause. And again, good cause would need to be due to the effects of COVID-19. So it can't be because you went on vacation for 2 weeks and didn't feel like dealing with it. If there's some reasonable explanation for the delay, the DUA, I believe, will be much more flexible. Any requirement that you attend seminars at the Mass Hire Center have been suspended, and all appeal hearings are going to be held by telephone only. Everything will be handled online, which is not that different. So here's another place where this unemployment as a result of COVID has changed our system dramatically. You may be ineligible to receive unemployment benefits if you become unemployed because of a layoff or your business shut down, taken in response to the virus. If you were laid off temporarily and you can return to work after a period of illness or quarantine. So, that covers if you were laid off temporarily, if you were furloughed. So if you're still receiving health benefits, you're still eligible for unemployment. If you're not receiving health benefits, you're still eligible for unemployment. If you had to leave work, not because your employer necessarily shut down the business or reduced the business, but if you had to leave work due to your own illness or quarantine or because of a family member's, you can apply and would be eligible for unemployment during that period of time. If you remain employed, but your hours or your wages have been reduced, you are eligible for unemployment. So here's where that earlier question comes in. If you are told by your employer that they can keep you on as an employee, but they can only pay you 50% of your normal wages, you could keep working and collect partial unemployment benefits. Similarly, if your employer tells you that they can keep you employed, but only on a part-time basis, meaning your hourly rate doesn't change, but you're only working, fewer hours than normal, you can apply and receive partial unemployment. If you are self-employed, this is very new and very different. If you're self-employed and unable to work due to COVID-19, you are eligible. That includes independent contractors and gig workers, freelancers. Again, the question is always unable to work. So if you're self-employed and you're able to work from home, you're not eligible. If you've been laid off from a church or religious institution that was previously ineligible, you may be eligible now. If you've been quarantined under an order by a civil authority or a medical professional, and again, I think I raised this a little bit earlier, but if you're prevented from leaving your home due to illness, if you have to care for someone else in your family who is sick or quarantined, or if you left employment due to a reasonable risk of exposure or infection. So I'll get into that last item, I think on the next slide, because it's a little bit of a gray area. But just know that for any of these reasons, you do not need to provide medical documentation, and you only need to be able to demonstrate that you are available for work when and as able. Okay, so just to kind of review that a little bit more, you are not eligible for unemployment benefits if your employer shuts down, but you can work full-time from home. So if your job is, you're able to do it on the computer, or it's done by phone calls or whatever, and you are able to do it entirely from home, then you're not eligible for unemployment benefits. If you're working full-time before the crisis and you can perform, part of your job, 50% of your job from home, you may be eligible for partial unemployment benefits. Unfortunately, you are not eligible for unemployment benefits if you are undocumented. The Lawyers for Civil Rights and other advocacy support groups have been advocating for the creation of a special fund for affected individuals and families to support folks who do not qualify for unemployment. At the end of the presentation, I'm going to identify a few organizations that are providing legal assistance and sometimes pro bono representation. These are also really good places to go in terms of the resources they have on their websites and through their Facebook groups, and in particular for folks who are undocumented. Lastly, this is if you left work because of a fear of being exposed to COVID-19. So you need to be able to demonstrate that you had a reasonable. So, if your workspace is completely isolated and you would not be exposed to any other people, you would have a harder time demonstrating that that fear was reasonable. If you are in a front-facing position where you would be interacting with people frequently, or if you yourself have pre-existing health conditions that make you particularly at risk, that would, I think, be found to be a reasonable fear of exposure. So, there's no black and white there. I suspect the DUA is going to be leaning in favor of folks who, have a true fear of being exposed, but it kind of remains to be seen how they're going to handle that. So the unemployment benefits that are available, for self-employed, independent contractors, and gig workers is new, and that comes under the Pandemic Unemployment Assistance. And that was something that was made part of the CARES Act, but it took quite a while for it to come to Massachusetts. But as of several weeks ago, self-employed, independent contractors, Lyft drivers, folks with limited work history are eligible. So previously you had to be able to demonstrate that you had been employed for a period of time prior to your unemployment. You don't have to demonstrate that anymore. If you're self-employed, if you're a sole proprietor, if you're an independent contractor and you are not able to work, or you're only able to work part-time, you would be eligible for benefits or partial benefits. Now, the way these benefits work is they would go retroactive to February 2nd, or the first week that you demonstrate you were unable to work, whichever's later. The benefits under PUA continue through the end of December 2020. There is an assistance guidebook that's available online, and we will, like I said, publish this, and you'll be able to click on that link for additional information. Okay, so filing for unemployment, everything is done online. Any kind of in-person service is suspended. The fastest way to file is to go to the DUA's website. I've provided the link to the login here, but you can just Google Massachusetts Division of Unemployment Assistance, and there'll be a box for filing a claim. Here I've provided a link to the guide for filing a claim. I believe that the Job Connector's second webinar in this series is going to walk through this process as well, so I encourage you to come back and attend that. When should you apply? You should apply right away. As soon as you learn that you're laid off, furloughed, that you're going to be working only part-time, any change in your employment that reduces your wages, if you're sick, if you have to stay home to care for somebody, you should apply right away. Again, if there's a delay and it's reasonable and it's due to COVID-19, I think you would be excused from missing deadlines, but in general, you want to apply sooner the better. So there is information online about when you would start to receive benefits. I think in general they're doing really well given the volume, but I wouldn't hold it to I wouldn't hold them to the day specifically. In general, once you've been deemed eligible to receive unemployment benefits, you have to certify your eligibility on a weekly basis. So every time that you certify that you're eligible, you should receive your benefits the Tuesday or Wednesday of that week. The DUA is saying that due to the volume, sometimes payment is delayed until Thursday. Your first payment may take a little longer because that requires them to process your initial claim. If you select direct deposit, that should hit your account after about 9 days from the date you request that payment method. If you've selected the debit card, it is supposed to come around the same time, but obviously once you receive that in the mail and activate it, you'll have access to your first payment. The DUA is not doing paper checks, so the two options are direct deposit or debit card. Under PUA, if you're approved for benefits, the first payment should be made within 4 to 7 business days if you choose direct deposit. And for everyone else, meaning a debit card, 10 to 14 business days. So I would say in general, the longest wait is going to be between when you first apply and you get your first payment. Thereafter, it should be fairly regular on a weekly basis. And how much money are you going to get? In general, you get approximately half of your weekly wages. That is capped out at $823. If you have a dependent child and you report that in your claim, you get $25 per dependent child per week. I can tell you that my dependent child costs more than $25 a week, but any amount is helpful. Now, as a result of the CARES Act, you get this additional $600 supplement for 13 weeks. And that goes through July 25th. it's retroactive. So if you became unemployed or unable to work several weeks ago and can demonstrate that, your payment should be retroactive. And again, the 13 weeks may or may not be extended depending on what happens and whether the government institutes additional legislation. There's an online calculator if you want to calculate your weekly benefits. There's a link here. And so, like I said, traditional unemployment benefits in Massachusetts are for 26 weeks, but under the CARES Act, you're entitled to 13 additional weeks, bringing you to a total of 39 weeks. What to do if there's a problem with your claim? Okay, so one thing that is really frustrating is that even when we're not dealing with an epidemic, it's difficult to get in touch with somebody at the DUA. A lot of times I have clients who just go there in person because they're frustrated with the phone system. You can't do that now because the offices are closed to the public. So there is a form on the DUA's website that you can use to contact them. I do not recommend using the form if you have kind of a general question. I recommend finding some other source, whether it's a lawyer, whether it's an organization like the Job Connector that could help you with this. But if you have special needs, there's a language barrier, and you need to contact the DUA, there is a form. You can use it if you don't know whether you qualify for unemployment benefits, if you need help applying, if you're having trouble logging in, or if you are looking to check the status of a claim that you've already filed. Again, I recommend trying to get in touch with the DUA or answering your question another way. I suspect that these forms are not being answered quickly and that many of them fall through the cracks. All right, so miscellaneous unemployment info. I would check for updates frequently, you know, as this epidemic evolves and states are discussing various levels of reopening as the federal government continues to discuss this. I suspect that additional changes will be made. So you should continue to check the Division of Unemployment Assistance website. They have a COVID-19 specific page there. If you are not a native English speaker, the DUA provides resources in Spanish, Portuguese, Haitian Creole, Chinese, Vietnamese, and several other languages. So if you click on this link, the mass.gov/multilingual #unemployment resources, they have PDF guides in multiple languages. And the Department of Unemployment is also offering virtual town halls. You can sign up for these town halls in English or Spanish, and that would explain the claim process. But again, you know, the Job Connector is providing a webinar on the claim filing process, and I encourage you to attend that. So these are some additional resources regarding sick leave. The FFCRA provides information through the Department of Labor, the Mass Earned Sick Time. So there are guidance documents available online that might provide some additional information for your specific situation. There's also frequently asked questions that are published online. I have some frequently asked questions at the end of this presentation. If we don't get to them, I encourage you to review them to see if they answer your question. But you can find additional FAQ published on the Department of Labor, on the Mass Attorney General's website, and at the Division of Unemployment. Okay, so before I get to questions, these are some organizations that can provide you with legal assistance, sometimes legal representation. The Attorney General's Fair Labor Division is the division that enforces the sick leave laws. So if you are looking for more information on that, looking to file a claim that your employer is violating that, you'd want to go to the Attorney General's Fair Labor Division. We've talked about the Division of Unemployment Assistance. They have lots of information and resources on their website as well. Those are both state agencies. Greater Boston Legal Services is a nonprofit organization. It's not part of the state. It provides free legal assistance and representation on civil matters, so that's non-criminal. But employment is one of the areas that they provide resources and assistance. Their website has a lot of information. That's a place I would go if you're looking to determine whether your employer is doing something wrong, whether you are entitled to benefits that you aren't getting. The Lawyers for Civil Rights is another organization that's doing really, really wonderful work. I would say, find them on Facebook. They have been publishing webinars and video presentations by the lawyers that work there very frequently. They do a lot of employment work. They do a lot of immigration work. And my understanding is that in particular with unemployment, if you have language issues, if you have questions and problems with the filing process and cannot afford to hire an attorney, they are offering some resources and helping folks through the claim filing process. So I really encourage you to reach out and look into Lawyers for Civil Rights. Mass Legal Help is another organization. I find their website a little bit more challenging to navigate, but I've put it here. And again, this is an organization that helps provide legal aid for folks who can't afford to retain an attorney. If you are looking for a lawyer, the Massachusetts Employment Lawyers Association is a bar association of plaintiffs' side employment lawyers. So employment lawyers who represent individuals rather than management or employers. massnela.org. They have a membership directory, which will give you contact information for about 160 employment lawyers in Massachusetts. Some, depending on the nature of the representation, some may take cases on a contingency fee basis and others may require an hourly fee. It depends. But again, if you're looking for a lawyer, I think that would be a good place to start. I will disclose that I'm the president of the Mass Employment Lawyers Association at the moment. But really, we're just an organization of attorneys who advocate for workers' rights and represent individuals. And I think that might bring us to the end. So I'm going to turn it back over for some more questions. And depending on how many questions we have, we may not get to the documented Q&A slides that I provided, and that's fine. We'll just publish those and you can review them. But I will turn it back over to the Job Connector and see if we can answer as many questions as we can.
Beth, thank you so much for your thoughts and presentation so far. And thank you to all of our participants. Our Q&A, we have lots of amazing questions. And if we're not able to get to your question, please feel free to reach out to us at the Job Connector by visiting our website. And also, the presentation and the PowerPoint will be made available for folks just in case anybody missed it and available to share. We have a great question, so let's begin. I have heard two different things when calling the unemployment department about the PUA. I am on it as a business owner with an LLC in Cambridge. For weekly reporting, I was entering gross, but now I am told I was supposed to be entering net each week. Am I really supposed to run a profit and loss and look up the net to report that each week? And do I enter a negative number if the net was negative for the week?
So that's a good question. Unfortunately, given that unemployment is so new, I have never myself assisted a client going through the filing process. All I can say is that, in general, answer as accurately as possible what they're asking for. If they are asking for your net pay, I would provide them with a net pay as best as you can. And if it's negative for the week, yes, I would indicate that it's negative.
Awesome, thank you. So is there a certain amount of time that an employee has had to work to be eligible for unemployment?
So this used to be, yes, you used to have worked for a certain period of time. Now those restrictions are greatly reduced, and I think, I don't believe there's any limit. For some of the sick leave and protected leave, you have to have worked for an employer for 30 days, but for unemployment, there's no longer a requirement that you have any kind of work history.
Awesome. Our next question is, if you were collecting unemployment benefits prior to COVID-19, will you get an extension? What if I've already exhausted my benefits last year? Am I now eligible again due to the CARES Act?
So yes, if you have, if you were in the middle of receiving benefits or your benefits had ended, you're entitled to the additional 13 weeks. Depending on how long ago your claim was filed, it's likely still open, and you can just apply for recertification through that existing claim. But I don't know that it would trigger the full 39 weeks. I think you would be entitled to the 13 additional weeks. And again, we can hope that there's some additional legislation passed extending that.
If an employer gets a PPP loan and you are told to come off unemployment, but you are unable to work because of lack of childcare, what would you be eligible for?
So a couple things. One is you could ask your employer whether you'd be entitled to use your accrued sick leave, so that 40 hours that you're entitled to under Massachusetts law. Second, under the federal legislation that was passed, you may be entitled to that 12 weeks of paid leave for situations like that, where you're home with your child. And again, that's protected leave, so your employer can't use that against you. They'd have to keep your job during that time. And I think the pay for that is 2/3 of your normal pay, and the first 10 days may be unpaid. So those are the two areas that I would look into in terms of benefits during that situation.
Awesome. Can employers be fined for breaking these laws, since there may be an inevitable delay between not receiving pay and receiving the assistance from the government? This can cause a huge hardship on families that live paycheck to paycheck and cause people to fall deeper into debt.
So yes and no. If the employer breaks the law, then yes, there are often civil penalties, and there may be a claim that you could bring in court, depending on the nature. What I think you've hit on is an issue that results just from natural kind of bureaucratic delay rather than any intentional wrongdoing. Sometimes there's a delay of several weeks between when it becomes clear that you are unemployed and when you start receiving your benefits through the DUA, and that can be incredibly challenging. What I will say is that unemployment is retroactive. So if you become unemployed and you apply and there's a delay of 10 days or 2 weeks or something, your initial check will be larger, that first check, because it will be retroactive to the date of unemployment. But I hear you, and there isn't always a legal right of action. And I will tell you that bringing a claim against an employer does not cure that initial period of hardship, because it's a lengthy process. What I would say is check out these legal resources that I've listed, because there are additional funds out there available for families and individuals that are separate from the federal sick leave and separate from unemployment. And these organizations like Lawyers for Civil Rights, like GBLS, they are working to prevent people who have food shortage or housing issues. So, there are other resources, and I encourage you to look out and see if you can find something that will help gap those delays.
Fantastic. And we have a little bit of time for 2 more questions. And again, if we don't get an opportunity to answer your question, please feel free to reach out to us through the Job Connector website, email. So if a nursing home worker has to use up their sick time due to COVID-19 and then needs to take other sick time, what are their rights?
So if you use your own sick time, you should have additional sick time under the new federal legislation, up to 80 hours if you are sick or a family member is sick. So that's 2 additional weeks of paid sick leave. Your employer, there's a floor and there's a ceiling. So your employer can't do certain things, but they are allowed to do more. They can't do less than what the statutes make them do, but they're perfectly entitled to do more. So it's up to your employer whether they want to continue to pay you for some additional time, if they want to allow you to use vacation time. But under that federal legislation that we talked about, you would be entitled to an additional 2 weeks of sick time. Now, if you are truly sick and unable to return for an extended period of time, you may be entitled to protected leave under the Family Medical Leave Act, which existed prior to all this, but that's not paid. So that's protected leave, meaning your job would be safe while you're gone, unpaid, and the only way that you would be able to extend payment is if you had some sort of short-term disability policy through your employer or otherwise.
Fantastic. And we have time for one last question. And because there has been a lot of questions and great need, Beth has graciously offered to stay on a little bit after the end of our presentation. So please feel free to stick around. So the last question is, if you had an offer for summer unemployment out of state that was withdrawn, do you qualify for benefits if the employment was only for the summer? Do you need to apply for unemployment benefits in that state?
This is like a law school exam question. Let me think. So in general, where you are employed is where you would be filing for unemployment. So if you were physically located at an employer outside of Massachusetts, I suspect that any right to benefits you need to look to those state laws. If you were employed by an out-of-state employer, but you were working out of your home, or you physically were located in Massachusetts, then you would be entitled to possible eligibility for unemployment. In a situation where you have a job offer that doesn't actually start, that's tricky. I don't know the answer to that, because the DUA has eliminated the requirement that you show a work history, but I don't know if that means you don't even need 1 day of work history. In general, I would say a job offer that's rescinded probably does not result in unemployment benefits, but I hope I'm wrong. In any event, like I said, if it's an out-of-state employer and you were going to be working out of state, you need to look to that state's unemployment laws.
Awesome. Thank you so much. And again, please feel free to stick around a little bit after the presentation ends to answer some more questions. And now I'd like to turn over to Sue Walsh, who is representing the City of Cambridge, to talk a little bit more about collaboration and some of our future programming.
Great. Thank you so much, Hector. This was such a rich presentation and conversation. There's clearly so much to learn. I want to thank Beth for her time today, and also our partners at the Job Connector. So as Junardi mentioned at the beginning of this webinar, this is the first in a 3-part series. And next week, our staff from the Office of Workforce Development and our Community Learning Center are going to look at this from a different angle. And they are going to take time to walk through the unemployment benefit application and really break it down step by step and highlight those areas that seem to be the most challenging or seem to trip people up. So it'll be a deeper dive into the actual application. Although remember, this is not filing your claim next week. It's just an opportunity to say, what does the application look like? What are the ways to think about your answers to these questions? So our amazing career advisors from the Learning Center, who have been helping students fill out their applications, and our manager of our Cambridge Works Transitional Jobs Program will be available to folks to answer their questions, to help those who have not yet applied figure out the best way to move through that quickly, and to help those who have had challenges applying kind of tease out what has worked and what hasn't worked so that they can move forward on their application. There's a slide on your screen right now for those who are interested in staying informed about COVID-19 city resources, what the city is doing to support residents, businesses, and families. Please make sure that you are signing up for those daily updates, and the information's on your screen now. So we are thrilled at the Department of Human Service Programs and with the city to have this partnership with the Job Connector at MIT. We invite you to please spread the word about next week's workshop. And there'll be a third in the series that will also be as wonderful as this one was. I know that there are other questions. I'm going to turn it back to Hector so that he can facilitate our additional time with Beth this morning. Thank you.
Fantastic. Thank you so much, Sue. And we love our partnership and collaboration with the City of Cambridge. So we're very thankful. We are going to answer a few more questions. The first one starting with, can we apply for both unemployment and paycheck protection program if we both have a W-2 and a 1099?
So if you're talking about a sole proprietor, I do not believe that you could collect unemployment and receive wage replacement through the PPP loan program. To be honest, I don't want to say that that is the definitive right answer, but unemployment, you are almost always ineligible for unemployment if you can demonstrate that you're receiving wages through some other means, and that includes sick leave, vacation pay, and the PPP is payroll protection loan, and you have to use, I think, 75% of the loan towards payroll if it's going to be forgiven. So if your PPP loan is replacing payroll and you are paying your employees, those employees would not be eligible for unemployment. That would be different if you were partially paying them. They might be eligible for partial unemployment.
Fantastic. Thank you. Do employees of 500 plus workplaces who get sick with COVID-19 have to file for pandemic unemployment to get sick time?
So if you work for an employer that has more than 500 employees, your employer is not bound by this additional 80 hours of sick leave or the 12 weeks of paid leave if their employees have children at home. But they are still bound by the Family Medical Leave Act and whatever their own sick time, sick leave policies are. If you are an employee in Massachusetts working for an employer that has more than 500, you're still eligible to accrue and use the Massachusetts earned sick leave. So you would have 40 hours of earned sick leave as a Massachusetts employee. If your employer has an additional sick leave policy and you've accrued sick or vacation time, you should be able to use that. And worst case scenario, if you are unable to return to work in a few weeks, you could request protected leave under the Family Medical Leave Act, which would again protect your job but doesn't provide pay. If your employer offers short-term disability and that's something that you took advantage of, you would be able to file for short-term disability benefits during that Family Medical Leave Act leave.
Moving to our next question. I got sick on January 16th with pneumonia. Do I qualify? And I was due to return to work on March 25th as a contract employee. However, I am in the Ticket to Work program.
So I might need a little bit more information about your situation, but if you got sick before all of this started, you wouldn't be eligible for unemployment during that period of time prior to the March date that this COVID CARES Act unemployment program kicked in. However, if you are unemployed, excuse me, unemployed or underemployed as a result of COVID, because the area of work that you're in as an independent contractor has been greatly reduced or affected, you could apply for unemployment benefits starting in late March, and you may be eligible for partial or full benefits retroactive to that date if you are presently, able to work but not working due to COVID's effect on the industry or something like that. I think that's how I understood your question. I hope that answers it a bit.
Our next question is, what if you were hired by an organization such as the US Census, but the hiring was delayed due to COVID-19? Are you eligible to get unemployment?
That's a good question. And that's similar to the question earlier about a job offer out of state. My answer is apply. Apply, and answer the questions through the DUA's application process truthfully. If you were given a start date, and I think it kind of depends on the certainty of the offer. So if there's kind of a casual job offer without all the kind of formality of processing you and onboarding you, I think it's a gray area. So if things were all set and you were supposed to start and things got delayed, I'd say you have a shot of getting unemployment, and I would at least try. I think that's less likely if things were kind of in the earlier stages and the higher date and your start date was a little bit more up in the air and informal.
Thank you. Our next question is, if someone works full-time from home, but lost hours at a separate part-time job somewhere, are they eligible for anything?
So it depends on what you mean by full-time from home. If you have more than one job and one of your jobs is impacted by COVID, partially or fully, in general, you could apply for unemployment and may be eligible for partial unemployment. If you are working a full-time job, that is 9 to 5 W-2 type job, I don't believe that you're going to be able to, I don't know what they're going to do with that right now. I don't want to give you an answer because I just don't know the right answer to that. So I apologize.
Awesome. No worries. Again, this is a ever-changing landscape, and so things change and they evolve, but we are here to help. Our next question is, do you lose your company health insurance if you file for unemployment? What do you do if you are sick with COVID-19 and your HR does not respond to your inquiries? Can you still apply without them?
So health insurance and unemployment are unrelated. Health insurance is not considered wages. If you're receiving health insurance from your employer, that does not make you ineligible. That would be similar to like a furlough situation. If you're receiving pay from your employer, you're not eligible. If your employer says, listen, I'll keep paying you while you're sick, and you're out of work because you're sick, you cannot also collect unemployment. The second half of that question was, it disappeared on my screen. If your HR, okay, so your HR department doesn't have to send you some sort of formal notice saying you've been furloughed or you've been terminated or whatever. If you aren't getting paid either, at all, or you're only getting paid part of your wages, or you're, only able to do part of your job, or the offices are closed down and you're not going into work and they don't tell you anything, what's actually happening to you is more important than what HR may be telling you. So if you are not working or you are working less due to COVID-19 and its effects on you or on your employer, you should apply for unemployment. You should look into whether you're entitled to these sick leave benefits. It doesn't matter what your employer is telling you. Unfortunately, I have heard of employers who I think probably were not reporting things properly, and had asked employees not to apply for unemployment and hold off to see if they received these PPP loans. That's improper. You can't do that. And an employee who's told, you can't work, we can't pay you, but don't apply for unemployment, that's not okay. You can apply for unemployment. The trickier thing is your employer going to hold that against you? Are they going to retaliate by not employing you back? And what I can say to that is, there's two sides to that. There's what would be unlawful for your employer to do, and then there's what your employer may actually do. And they are not always the same. People do things that are unlawful all the time. So in general, your employer doesn't have to give you the A-OK to apply for unemployment. It matters more about what's actually happening to your employment status and your pay that you're receiving.
Our next question is, can you apply for unemployment if your wages are decreased by a percentage?
Yes, so you'd be entitled to partial unemployment. If you agreed to a 20% pay cut, you'd be entitled to file for that 20% that you are not receiving as a result of COVID.
If you are self-employed and can work entirely from home, but become sick from the virus and cannot work, are you eligible for unemployment?
Yes, if you are unable to work, I would apply for unemployment, and you should be able to collect during the period of time that you are sick and unable to work.
Our next question is, if a person works but does not file taxes due to jobs being word of mouth and private, could they collect UI benefits?
So, if you're working under the table, in general, no. Your employer needs to be paying into the unemployment system. That situation depends, though, because usually it's the employer that would be on the hook for that. And so without knowing more about the situation, I don't want to provide an answer, but in general, there has to be, unemployment works with the Department of Revenue, and they confirm wages through 1099s and W-2s and things like that. So in general, if you are working under the table and not reporting, that is not, I think you're going to have a problem applying for unemployment, but you also may trigger some issues for the employer that's paying you under the table. So if it's a situation where the employer is taking advantage of employees by not handling their wages properly, that's one situation. If it's like two friends that are, doing each other a favor or whatever, I think it kind of depends on the situation.
Fantastic, thank you. Our next question is, can you claim back to the first date you left work due to COVID? Is a doctor's note enough?
Yeah, so here's where, in general, my advice is apply as soon as possible. But if for some reason you didn't know that you were entitled to unemployment, or the federal legislation had not gone into effect, if you have been out of work since late March and you apply, the benefits should be retroactive to the date that you became unemployed. Again, if you can demonstrate that the delay in filing was reasonable, that's going to be helpful. If you've been sick this whole time, that's going to be helpful. But I'm guessing that the Division of Unemployment is going to be more lax with deadlines, given how much things have changed and how frequently things are changing. So my advice is apply and enter the date that you became unemployed. That was, several weeks back, and hope that the first payment is retroactive to that date.
Our next question is, if I am applying for a fiance/spouse visa, can I apply for UI?
Good question. I don't know the answer to it. I suspect that if you are in the application process, the answer is no. If you are finalized, I don't know the answer to that. And I think that would be a question for lawyers for civil rights, because they have a better intersection of immigration and employment law.
Our next question is, why would someone opt for the FFCRA if they can apply for UI or PUA, particularly with the additional $600 a week? Is the FFCRA an option for immigrants that worked without work authorization and therefore ineligible for UI and PUA?
It's a good question. So you'll recall that the FFCRA provides that 80 hours of paid sick time for folks who are sick or caring for somebody who's sick, and then the 12 weeks of pay for folks who have a child at home. So the question is, why would you use that paid sick leave instead of applying for unemployment? I think my guess is that you'd want to figure out what makes the most sense and for what period of time you're likely going to be out. You cannot collect both. So the PUA is for self-employed independent contractors. If you're employed by an employer and you receive W-2 wages, that's not, the PUA is not something that you're going to be able to seek benefit from. So the question is whether you are unemployed for a reason that would make you eligible to receive unemployment benefits. And again, I think it may be a little bit of a case-by-case analysis depending on what your ongoing relationship with the employer is. But I think you'd want to determine what your benefits would be, and under what situation you'd have the most resources. I know that under the FFCRA, they can't force you to use your own sick time before making use of the FFCRA. So they couldn't force you to use that 40 hours of accrued sick leave as a mass employee before using the 80 hours under the federal legislation. I'm just trying to think through situations where you would be entitled to unemployment and not the sick leave. I'm suspicious that if you're eligible for the sick leave, you may have to take advantage of that prior to the unemployment. But to be honest, I would need to look into that.
Awesome, thank you. What can someone do if they weren't able to request the first 2 weeks of payment after they were determined eligible? DUA called back and the person got nowhere.
Yeah, so it is really challenging if there's an error or something in the claim process, how to remedy that. This is where, I might try and reach out to someone like the Job Connector or the Lawyers for Civil Rights and see if they have had any luck helping folks to remedy errors like that. Alternatively, sometimes at the end of your claim process, there's like a exit questionnaire type thing, and it may be possible to rectify it at the end. I'm not entirely clear on what you mean. If the DUA determined that you were ineligible for those first 2 weeks, or if there was just an error in the process. So I would probably have to try and reach out to a lawyer or one of those legal aid agencies and see if they could help you out.
Awesome, thank you. Should recurring summer camp employees who are not rehired this summer because they don't reopen apply?
I'm sorry, can you say that one more time?
Should recurring summer camp employees who are not rehired this summer because they don't reopen, should they apply?
Yes, I would say yes, apply. I think, that's a situation where you can demonstrate that you've worked for them before and it was anticipated that you were going to work for them again. And it's more certain than maybe an early offer of employment. I would say absolutely apply.
If you are in the Ticket to Work program, can you collect if you are working?
So again, this would be kind of a case-by-case analysis. In general, if you are receiving wages of any form during a week, you have to report that when you're certifying for benefits for that week. So if you work, 1 day, you have to report that. If you work 3 days, you have to report that. And in general, your weekly benefits will be reduced by the amount you work, sometimes dollar for dollar over a certain amount. So again, partial or part-time work that isn't completely full-time may reduce your benefits some, but it's not going to it should make you ineligible.
Our next question is, I have staff who were furloughed, were recalled, but due to childcare issues can only work part-time. They want to know if they can still collect partial unemployment. Is this possible? They have been told to go to the FMLA.
Okay, so employees are partially furloughed, but then further unable to work because they have kids at home.
Yes.
So I would say, clearly eligible for the partial furlough. If you're told you can work from home 20 hours a week instead of 40 hours a week, you should apply for the 20 hours that you're not working. Then, due to the childcare issue, the federal statute we talked about that offers that 12 weeks of paid leave at 2/3 your pay rate, I think those two would be overlapping. The FMLA is the statute that existed before all of this COVID-19, and that provides protected leave for 12 weeks, but unpaid. And again, that would be a situation where if you were stuck at home with kids and had exhausted the 12 weeks under the FFCRA, you may be entitled to add FMLA onto that, but it would be unpaid. Again, I think, it's going to be important to see what happens in the next few weeks and months, because a lot of these programs and statutes that came out with periods of time, whether it was 80 hours for sick, and then this 12 weeks, if schools remain closed for, another 4 months, I suspect that we may see changes to the legislation. But the goal was to provide paid leave for parents while schools are closed. So, we have to kind of see what happens in terms of extensions.
Fantastic. Thank you so much. So we have time for 2 more questions, but don't forget that this presentation and the PowerPoint will be made available on our website, on the Job Connector website, but also don't forget to follow us on Facebook and Twitter to stay up to date. Our next question is, are people eligible for unemployment if they've been working from home, but are asked to return to the work site in a public-facing role, but are afraid to do so because of COVID-19?
So this is unfortunately a question that a lot of people are faced with. Again, this is a gray area. And what the DUA is saying is that you have to have a reasonable fear of exposure. And so what does that mean? I would say your chances of being determined eligible for unemployment in a situation like that increase if, like, the more front-facing your job is, the more people you're going to come in contact with. If you yourself have pre-existing health conditions that make you particularly vulnerable, if someone you live with have existing health conditions that make you particularly vulnerable, if a healthy person who has no known risk factors feels really, really uncomfortable in a public-facing role and says, I can't do it, I'm too concerned. I would hope that the DUA is going to find you eligible. I think that's kind of the purpose behind a lot of this legislation, but I do think it's a little bit unclear. It also has to do with, if the state, what the state guidelines are right now around essential versus non-essential businesses. And, if you are a non-essential employee in a non-essential business and you are being asked to do something that exposes you, I think you're going to have a much better chance of demonstrating eligibility for unemployment than if you're an essential worker, or once the state has started to loosen up and folks are starting to open up a bit more. But it is a little bit, I've heard from a lot of people that are in the same situation, and I think it's unclear, but I think you should try.
All right, and we have time for 1 more question. I work with someone who left their job working in a nursing home that was highly infected. They have since tested positive for antibodies. Should they apply?
So, it sounds like I'm guessing, the original reason he left work was fear of infection, or maybe his actual infection. And so if you're sick, you are entitled to unemployment during that period of illness, unless you're receiving some other kind of paid sick leave. If you thereafter have concerns that you would be reinfected, or you would somehow, be exposing family members or others, that falls into the same question that I just answered, is your refusal to work reasonable? And I think given the science about this virus right now, I think it's really unclear whether folks are susceptible to reinfection, and whether that you are even, in more danger if you're reinfected. I think I would hope that the DUA in that situation would find your hesitation and reluctance to go back reasonable. But again, I think that's a bit of a gray area. I would certainly point to, your concerns about your compromised immune system, given having just come back from the virus, talking to your healthcare professionals about, are you at an enhanced risk of becoming reinfected? Again, you don't have to provide medical documentation, but if you report as part of your filing claim, my doctors have told me that I am at a higher risk of exposure, I would tell them that.
Fantastic. So Beth, we want to thank you for all the information that you shared and your thoughts. This has been extremely enlightening and extremely helpful information. We want to thank our participants for joining us today. You've been able to ask so many questions. They've been amazing. And so if you have any other questions, please don't forget to reach out to us. The URL links to our website and Twitter and Facebook are in the chat. So please don't forget to like us and follow us to stay up to date for more information around virtual programming. We also want to thank our friends and colleagues in the Office of the Government and Community Relations with MIT, and our friends in the city of Cambridge for their support and collaboration for this virtual webinar. Again, this information will be made available on our website, and the PowerPoint will also be available for folks to share and with their community and their networks. So we want to thank you again, and we look forward to seeing you again next week for our virtual webinar. Thanks again.
Thank you.